I would like to begin as promptly as possible, and Paul Reichler has a lot to tell us. I simply want to say at the outset that Timothy Gillette was one of my favorite students. He ended up practicing law with me and many others engaged with China. He was an expert in Chinese, French, and English language legal concepts. He taught law at NYU part-time while practicing, and his untimely death at age 39, 23 years ago, led me to think that we should remember him in some appropriate way. And every year we do this program on some aspect relating to Asia and especially China, which was his first love. Second, this is a great experiment. Not only will we start off with an introductory address by Paul Reichler, who's well known to many, but then we're going to try to use a discussion format in order to maximize exchange and focus in an orderly way, issue by issue. We have a distinguished group of speaker participants. You have their biographies in the program, and we hope that those of you in the audience will take advantage of the opportunity to comment and ask questions. This is a very significant moment, made more significant by the uncertainty produced by our election on Tuesday, and international law will play a very important role in the future. And I think it's incumbent on those of us who have invested in learning about international law that we do what we can to enhance public education. So I welcome you all, and I'm glad to see Paul Reichler is here. He's going to talk, and then we're going to have a chance to comment and ask questions before we go on to the first discussion panel. Paul, everybody knows what your bio is. I'm not going to waste a moment. I want to hear what you're going to tell us about how to find a path to a peaceful solution of the South China Sea.
Well, thank you very much, Jerry. It's an honor to be here or anywhere where you are, and especially to be at a table with such distinguished experts and in a room full of such distinguished people. I've been asked to speak about the path to a just and lasting peace in the South China Sea, and that, of course, is a very ambitious title, and I may not live up to that, but I will do the best I can to give you my most considered thoughts on the subject. You start by telling you that at the time the Philippines, can everybody hear me? Is this, am I speaking loud enough? Okay, good. At the time the Philippines decided to institute arbitration proceedings against China under the UN Convention on the Law of the Sea, it faced a very daunting challenge. First, China was insisting on exclusive jurisdiction over nearly all the waters and seabed of the South China Sea within a so-called 9-dash line, and the exclusive right to all of the natural resources within that line. On the slide, you can see China's own depiction of its 9-dash line, which it first made public in 2009. First made public as a line claiming sovereign rights, exclusive sovereign rights, within all the waters and seabed encompassed by the 9-dash line. Let me see. China's claim, and you can see it here depicted a little more clearly with the red dashes. China's claim extended more than 650 miles from its mainland coast, and within 50 miles of the Philippines coast, and that is well inside the 200-mile exclusive economic zone and continental shelf to which the Philippines is entitled under the Law of the Sea Convention. You can see in pink, this is the area claimed by China beyond its lawful entitlements under the Law of the Sea Convention, that is beyond its own 200-mile maritime entitlements. Second, Chinese naval and law enforcement vessels prevented Philippine fishermen from fishing in these waters and prevented Philippine licensees from exploring for oil and gas within the perimeter where the 9-dash line lies, while permitting Chinese nationals and only Chinese nationals to carry out these activities. Third, China claimed sovereignty over all of the Spratly Islands, which you can see depicted in the southern part of the South China Sea, which consists of dozens of tiny insular features, only a small number of which are above water at high tide. And these were also claimed by the Philippines, Vietnam, and Malaysia. China had occupied and built or started to build military facilities on top of 7 of these features. One of them, Mischief Reef, was a low tide elevation only 120 miles off the Philippines coast and well within its exclusive economic zone and continental shelf. Fourth, the Chinese construction activity on these small islands had destroyed, and in some cases obliterated, coral reefs, previously some of the most pristine in the world, causing devastating and irreparable harm to the surrounding marine environment, including important fish breeding and feeding areas. And fifth, China had forcibly excluded Filipino fishermen from Scarborough Shoal, a series of rocks jutting above the water around 100 miles west of the Philippine coast at Luzon, and you can see it off the third 9-dash line from the top in the east. This was a fertile, or is a fertile fishing area where Filipino as well as Chinese fishermen have exercised their livelihood for centuries. After June 2012, only Chinese nationals were allowed by China to fish at the shoal, although this may be changing at the present time. The Philippines had tried to address all of these issues with China by diplomacy, but China had been inflexible. It demanded that the Philippines accept China's exclusive sovereign rights over all of the resources of the sea and seabed within the 9-dash line, as well as Chinese sovereignty over all of the islands and other marine features in the South China Sea. This would have amounted to a near complete renunciation of the Philippines' rights under the Law of the Sea Convention. Negotiations took place at various intervals over several years, always following the same script. No progress toward an agreement was or could be made under China's conditions. With diplomacy frustrated and military action out of the question, legal recourse, appeared to be the only viable option for the Philippines. But this, too, posed some serious challenges. The difficulty facing the Philippines was how to frame a case under the Law of the Sea Convention that would accomplish 2 critical objectives. 1, meet the jurisdictional requirements of Part 15 of the Law of the Sea Convention, and 2, obtain meaningful relief for the Philippines. There were obstacles to jurisdiction looming over the case. First, a tribunal established under the convention has no jurisdiction over questions of land sovereignty. And for that reason, the Philippines could not challenge China's assertion of sovereignty over the Spratly Islands or Scarborough Shoal, which represented one of the main sources of conflict. Second, the Philippines could not ask a tribunal to delimit a maritime boundary with China because China had exercised its right under Article 298 of the Convention to exclude itself from compulsory arbitral jurisdiction in regard to sea boundary delimitation. The solution, after much thought, analysis, and debate, was to bring a case about maritime entitlements rather than sovereignty over islands or delimitation of boundaries. Maritime entitlements, that is, the entitlements to the sea and seabed generated by mainland coasts and islands, including a 12-mile territorial sea and 200-mile exclusive economic zone and continental shelf, are specifically provided for in the convention, and thus, unlike sovereignty over land territory, fall within the jurisdiction of a tribunal established pursuant to Part 15. Also, and this proved to be a critical point, entitlements can be determined without the need for engaging in the delimitation of boundaries. In fact, law of the sea tribunals must determine the entitlements of the parties to a dispute prior to and separately from delimiting a boundary, because it is only when the two states' entitlements overlap that a boundary needs to be created. And these slides illustrate the point. Here, State A and State B are separated by 500 miles. Each state has a 200-mile entitlement. There is no overlap, and thus there is no need for a boundary delimitation. A tribunal can simply confirm the rights of each state within and up to 200 miles. By contrast, here State A and B are 300 miles apart. As you can see, their 200-mile entitlements overlap. That's the shaded area. In this case, because there are overlapping entitlements under the Law of the Sea Convention, a boundary delimitation is required to determine which state enjoys rights within which part of the shaded area. Now, our legal team, which I'm very proud to say included Professor Oxman, from whom you'll hear later, was confident that by asserting claims based on entitlements rather than sovereignty or delimitation, we would overcome China's anticipated jurisdictional challenges. And this proved to be correct. Although China did not formally appear in the proceedings, it submitted to the arbitral tribunal a very well-written position paper, which the tribunal construed as a formal pleading, setting forth jurisdictional objections. China's main arguments were that the tribunal lacked jurisdiction over matters of land sovereignty and boundary delimitation. The tribunal had no difficulty in rejecting these arguments unanimously because, as it emphasized, the Philippines had taken pains not to raise issues of land sovereignty or boundary delimitation, but had presented its case entirely as one regarding maritime entitlements. Now, that left us with the question of whether a case about maritime entitlements alone would be enough to justify the Philippines' recourse to arbitration, insofar as it could produce an award that obtained meaningful relief in the form of confirmation of the Philippines' exclusive right to enjoyment of the resources within its 200-mile exclusive economic zone and continental shelf. And the next slides illustrate why our decision to focus on entitlements was sufficient to accomplish this objective. This slide shows the 200-mile entitlements generated by China's and the Philippines coasts. As you can see, there is very little overlap, except for a small area off the Philippines' northwest coast. None of the Philippines' entitlements are overlapped by the Chinese entitlements extending from China's mainland coast. The Philippines thus enjoys exclusive entitlements in all of these non-overlapped areas, including the right to all the resources of the sea and seabed. For this reason, the most important objective of the case, from the Philippines' perspective, was to establish the unlawfulness of the 9-dash line claim and limit China's entitlements to those set forth in the convention, which are north of the red line on this slide. The Philippines argued that as a party to the convention, China enjoyed all of the entitlements set forth therein, but that these did not extend beyond 200 miles. Therefore, any Chinese claim beyond 200 miles, especially one that extended within 200 miles of the Philippines, was a violation of the convention and of the Philippines' rights thereunder. This, frankly, seemed to us an irrefutable point, and the tribunal agreed unanimously. Now, in reaching this decision, the tribunal carefully considered China's claim to the waters and seabed encompassed by the 9-dash line based on so-called historic rights, beyond those enumerated in the convention. The tribunal found that China's claim was unlawful on two grounds. First, after a very careful and thorough review of the convention's text and its voluminous travaux préparatoires, the 5 arbitrators concluded that when states become parties to the convention, they abandon all claims to rights in the sea, whether based on history or otherwise, that are contradictory with the convention's provisions, and that the convention expressly requires its parties to withdraw such contradictory claims. China's claims to areas of sea and seabed beyond 200 miles from its mainland coast were plainly contradictory to the convention and were therefore unlawful. Second, the tribunal found that even under pre-convention international law, China's historic rights claims were invalid. Under customary law, a claim of historic rights may be lawful only if a state has exercised authority over the maritime area in question under a claim of right continuously over a long period of time and with the acquiescence of neighboring states. To be sure, Chinese fishermen had visited areas throughout the South China Sea since time immemorial, but China had never exercised authority over any maritime areas beyond those very close to its mainland coast, let alone continuously for a long period of time. And no other state had ever acquiesced to China's authority in these areas. Now, China's claimed 200-mile entitlements, that is, China's lawful 200-mile entitlements, extended not only from its mainland coast, but China claimed that it also enjoyed 200-mile entitlements from Scarborough Shoal and the Spratly Islands, over which it claimed sovereignty. So consequently, another equally important issue in the case was whether these features were capable of generating maritime entitlements, and if so, to what extent. And this matter turned on the meaning of Article 121 of the Convention. That article provides that islands generate the same maritime entitlements as mainland coasts, including a 200-mile exclusive economic zone and continental shelf. But there is an exception in paragraph 3 of that article for islands that are considered uninhabitable, specifically features that are incapable of sustaining human habitation or economic life on their own. Those islands have an entitlement only to a 12-mile territorial sea. Accordingly, the Philippines argued and presented voluminous cartographic, historical, anthropological, and scientific evidence that neither Scarborough Shoal nor any of the Spratly Islands was habitable in its natural state, and therefore that none of them generated entitlements beyond 12 miles. And significantly, this was the very first case in which any international court or tribunal was required to interpret or apply Article 121.3, or determine whether and on what basis an island should be deemed incapable of sustaining human habitation or economic life. The tribunal, which was composed of 5 of the most eminent and well-respected jurists and experts on law of the sea, delivered, as part of its award, an extensive analysis of the text and the manner in which it is to be applied. It came to the conclusion, again unanimous, that none of the islands in question was habitable in its natural state, and that none of them therefore generated entitlements beyond 12 miles. The result was as shown here on the slide. As you can see, in the area around the Spratly Islands, when these islands, even under the assumption that China is sovereign over them, are given 12-mile entitlements, there are only very small areas of overlap with the entitlements that lawfully pertain to the Philippines. And on this basis, the tribunal ruled that it was unlawful for China to deprive the Philippines of the exclusive enjoyment of these non-overlapped areas of sea and seabed in its exclusive economic zone and continental shelf, including all the living and non-living resources located there. Now, in regard to the impact of China's island building and other activities on the marine environment, the tribunal retained its own independent experts to assess the harm caused by these activities. They found that the harm caused by China to the marine environment was devastating and irreparable, as the Philippines had claimed. And finally, the tribunal considered fishing at Scarborough Shoal and found, based on the historic evidence, that both Filipino and Chinese fishermen had conducted traditional fishing activities at the shoal for centuries without interference by any governmental authorities. On this basis, the tribunal concluded that regardless of which state is sovereign over the shoal, a matter that was beyond its jurisdiction to decide, the fishermen of both states enjoy traditional rights to engage in the same practices that they have historically exercised. This meant that China could not continue to prevent Filipino fishermen from exercising these rights. In essence, the Philippines prevailed on all of its central claims. But as many have asked, what does this mean if China refuses to comply with the award? And that is what I will discuss in the remainder of these remarks. This is a legitimate question, and one that reaches beyond China and this particular case. Put more broadly, the question might be phrased, what does it mean for the law of the sea and for the rule of law in general if states, especially great powers, refuse to comply with their legally binding obligations under treaties to which they voluntarily become parties, or with their obligations under judicial judgments or arbitral awards rendered by duly constituted and fully competent international courts or arbitral tribunals? My first observation is that given the nature of the case, it would be extremely detrimental to the international legal order for China's defiance of this arbitral award, if that is what China persists in doing, to be acquiesced in by the international community, and especially by the more than 160 states parties to the Law of the Sea Convention. China's actions, especially its insistence on enforcement of its 9-dash line and historical rights claims, have been found to violate the most fundamental principles of the Convention, in derogation of the rights of the Philippines and, by implication, those of other coastal states along the South China Sea. This is a very special convention. It was envisioned by its framers, including China, as a constitution for the world's oceans and seas, regulating virtually every aspect, from navigation to environmental protection, to boundaries, to maritime zones and rights to resources, to undersea cables, to deep seabed mining, and on and on. It has been one of the most successful treaties in the history of international law. It enjoys near universal acceptance, and it has kept peace and order on the seas and facilitated the orderly and equitable exploitation of resources for more than a generation. China's policies and actions currently threaten the viability of the convention. If China can disregard the convention, then so can other states. This should be unacceptable to the international community. It should also be unacceptable to China. China itself has much to lose from the unraveling or weakening of the Convention. It has extensive rights under the Convention that it would not want to put in jeopardy. It might one day find these same rights threatened by other great powers, including in the South China Sea. The Convention would protect China in these circumstances. The United Nations Charter gives a special role to certain of the world's most powerful states, including China. It makes them permanent members of the Security Council, and it gives them veto power over Council resolutions. But it does not exempt them from the rules set forth in the Charter or any other rules of international law. Nor do United Nations conventions or other multilateral treaties make exceptions to their rules for the great powers. The same fundamental legal rules and principles reflected in international legal agreements, like the Law of the Sea Convention or adopted by custom, apply to all states. And it could not be otherwise. The majority of states simply would not accept being bound by rules that exempted other states solely on the basis of their size or power. They simply would not accept a system in which they are required to comply with the binding orders of competent international tribunals, but other states, the great powers, are not. The great powers set an example, and this can be either good or bad. If they refuse to honor their legal obligations, so will other states, and soon enough, international adjudication will be a hollow exercise. In 2012, when Colombia defiantly told the ICJ it would not comply with the court's judgment delimiting its maritime boundary with Nicaragua, it cited the United States' rejection of the judgment in the landmark case brought by Nicaragua in the 1980s. China, too, cited the U.S.'s reaction to the Nicaragua judgment in support of its rejection of the arbitral award in the Philippines case. Fortunately, these acts of defiance of international courts and tribunals are, at least so far, rare exceptions. The vast majority of states, in the vast majority of cases, comply with judicial judgments and arbitral awards, even in cases where they consider themselves to have lost. The United States, despite the Nicaragua case, has a decent record of compliance with international judgments and awards. And so too does China, at least in the context of World Trade Organization panel rulings. China has been complying even with those rulings that go against it. There are reasons why states, on the whole, generally comply, even with unfavorable judicial or arbitral outcomes. First, there is an advantage in finally resolving a dispute with another state. Even if the resolution is less than desirable, prolongation of the conflict, tension and instability in the bilateral relationship, and the imminent or eventual possibility of armed conflict is often worse. Second, neighboring states can never move out of the neighborhood. Geographical proximity among states is permanent. Disputes between neighbors are inevitable. If state A doesn't comply with the judgment or award resolving today's dispute, how can it expect its neighbor state B to comply with one resolving tomorrow's dispute? By refusing to comply, state A will have removed judicial or arbitral recourse from the list of possible means of resolving a future dispute that cannot be settled diplomatically. What alternatives does that leave it? Third, there is the value of stature, prestige, and reputation, which translates into influence on the international level. States enhance their stature and with it their influence when they demonstrate that they are law-abiding, including by complying with international judgments and awards. For this reason, states inevitably seek to justify their actions on the basis of international law. We see this in all kinds of situations, even where the reliance on international law seems misplaced. China itself has argued that its 9-line claim is based on international law, namely its alleged historic rights to far-removed waters and seabed. For the reasons I explained, the arbitral tribunal dispensed with this argument. But my point here is not that states correctly invoke international law to justify their policies and actions, simply that they do so. And that is because they consider it important to their own self-interest to be seen by their neighbors and the international community as a whole as law-abiding and respectful of the rights of other states. Why do they care? Because it enhances their stature and thus their influence. And finally, I believe that the majority of states understand that the alternative to a rules-based international order is chaos. Respect for the rule of law not only serves ethical and moral interests, including justice and fairness, but practical ones. It fosters predictability, stability, security, and peace in international relations. These are goals shared by most states most of the time. In fact, great powers may have the greatest interest in preserving the existing international order and their privileged levels of influence under it. Maintaining and strengthening that order requires them to accept the consequences on those occasions when its rules are applied against them. No great power can reasonably expect to win automatically every time. There will be times when their behavior is found to be unlawful. But that may present as much of an opportunity for strengthening the legal order as a challenge to it. There might be no better way to promote the rule of law than for a great power, like the United States or China, to accept and comply with an adverse judicial judgment or arbitral award. In fact, they do so, at least from time to time, because they do understand that there is no viable alternative to a rules-based system that will protect, over the long term, their interests in a more orderly and secure world. In addition to these systemic considerations, there are particular reasons, in my humble opinion, why China, at least with the passage of time, the dilution of passions, and the sober-minded reflection of an enlightened leadership, might come to see the award in the Philippines case as more of an opportunity than a defeat. First, China may appreciate that its core interests in the South China Sea have not been affected by the award. China's claim of sovereignty over all the islands, which it considers vital to its strategic interests, is unaffected by the award. Accordingly, to comply with the award, China need not relinquish either its sovereignty claim in general or its control over the small islands or rocks it currently occupies for military or other purposes. The only exception is Mischief Reef, which is not an island, but a low tide elevation lying well within the Philippines' exclusive economic zone. Likewise, the award does not diminish China's freedom of navigation or overflight, or ability to conduct naval exercises or other military activities in the South China Sea. China itself proclaimed that even under the 9-dash line claim, it would respect the navigational and overflight freedoms of other states in and above the relevant waters. Under the award, the Philippines must respect China's freedom of navigation and overflight within the Philippines' own exclusive economic zone. China's freedoms of navigation and overflight, therefore, including for its naval and air forces, are therefore fully protected. What have been protected by the award, principally, are access to resources and protection of the marine environment. China may no longer lawfully claim for itself exclusive entitlement to all the resources within the 9-dash line, but must respect the exclusive economic zones and continental shelves of the Philippines and the other coastal states in the region. China also may no longer lawfully destroy environmentally sensitive coral reefs and their ecosystems for the purpose of building and expanding artificial islands. But these should not be difficult pills for China to swallow. Until now, China and its neighbors along the South China Sea have been engaged in a competition for resources, especially fish and hydrocarbons, oil and gas. China's claim of exclusive entitlement to these resources based on the 9-dash line was explicitly rejected by all of the other coastal states even before the arbitral award. China had to resort to shows of force on various occasions against vessels and nationals from the Philippines, Indonesia, and Vietnam to enforce its 9-dash line claim. Until now, until the award, there seemed to be no solution, and the risks of conflict were growing. The award provides an equitable basis for a solution of this conflict over resources. To be sure, it reinforces the positions of the Philippines, Indonesia, Vietnam, and Malaysia, among others, on the unlawfulness of China's 9-dash line claim, and encourages them to continue to assert their rights as against China within their own 200-mile exclusive economic zones and continental shelves. But at the same time, the award provides a path for China to negotiate its way out of a dangerous impasse of its own making and avoid a prolonged and destabilizing conflict, not only with the Philippines, but with Vietnam, Indonesia, Malaysia, and others as well. This certainly raises the stakes for China to ultimately find an accommodation with at least the 4 largest of its Southeast Asian neighbors, all of which have rejected China's claims and are unlikely ever to acquiesce in them. On some of the disputed issues, like protecting the marine environment, China and its neighbors would appear to have common interests. On others, compromise should be possible. Unlike sovereignty, resources, whether fish or hydrocarbons, are divisible. By recognizing that its neighbors, too, have rights, as set forth in the Law of the Sea Convention and reaffirmed in the arbitral award, China would be able to free itself to negotiate equitable sharing arrangements in regard to fish catches and oil and gas development. More, China can become the indispensable partner to its neighbors in these activities. It is the only coastal state along the South China Sea with the financial and technological capacity to facilitate exploitation of oil and gas without participation from Western or other extra-regional players. Good faith negotiations based on respect for the legal rights of all the coastal states, including China, could produce a settlement favorable to each one of them. For these reasons, I believe the award offers China, as well as the Philippines and the other coastal states along the South China Sea, the best path toward a secure, just, and lasting arrangement for the peaceful and equitable enjoyment of the sea and its resources. And this is why I believe it can be hoped that China, in its wisdom, will come to the same conclusion and find an honorable way to reach a reasonable accommodation with its neighboring states based on its recognition of their and China's own fundamental rights under the Law of the Sea Convention as spelled out in the arbitral award. In my view, such an agreement would serve the interests of China, the Philippines, the other coastal states in the region, and the international community as a whole. This is clearly within the realm of possibility. It requires mainly for China to come to the enlightened conclusion that its long-term interests, like those of most other states, are best served by respecting, promoting, and strengthening the rule of law, and by accepting the legal rights of its neighboring states in return for their acceptance of its rights and their willingness to accept it as a partner in the sustainable and equitable enjoyment of the South China Sea and its resources. Thank you very much.
We've just heard a very strong and imaginative and positive, I think, account of what may be taking place. Rather than have a very brief question-comment period at the moment, I think it would be most appropriate to go on now to our jurisdictional questions with the help of our introductory speakers. But my only question at this point, Paul, is can we have the benefit of putting that on our website and making that talk available? It's not a state secret any longer, is it?
Well, I'm not a state, and I'm not here speaking on behalf of one, so it certainly isn't a state secret. But frankly, I'm very flattered and honored that you would consider it worthy of putting on the website, and I grant you my permission to do so.
Thanks. I'm glad we have a lot of witnesses to that, because I think it would be a very valuable contribution, and it would make it immediately available at a time when there may be some positive movement underway. Well, this was a terrific start, and now we're going to get down to some of the fundamental questions of jurisdiction. And I wanted to ask Professor Oxman, in the light of what we've heard, to make some comments, and then we'll have Dr. Hong Nong give her own views on this, and then we'll open it to discussion among people at the table and in the audience. But you've given us a very fine start, Paul. Thanks so much. Bernie?
Thank you very much. It's great to be here. I'm in the unenviable position of following that truly splendid and thought-provoking presentation by Mr. Reichler, with whom it was my honor to work in the arbitration. I suppose that means I too should make clear that I am not here in my capacity as a member of the Philippine team in the arbitration. What I say does not necessarily reflect the views of the Philippines, and I'm here in a purely academic capacity, which means I can be and probably am wrong. Paul's statement also makes it a little bit easier for me because he has covered some of the jurisdictional issues, and I will try to, therefore, not go over the same ground that he did. Let me step back for a second and just very quickly review, if the experts will bear with me, what the convention has to say with respect to matters that bear on the jurisdictional issue. China, by the way, as you know, ratified the Law of the Sea Convention in 1966. Philippines had done so in 1984. They've joined many other states as parties to the convention. Now, Article 286 of the convention provides that, subject to certain exceptions, which we'll get into, any dispute concerning the interpretation or application of the convention shall, where there's been no settlement by other means, be submitted at the request of any party to the dispute to the court or tribunal having jurisdiction under that part of the convention. This is the consent to jurisdiction. We are not here dealing with a situation in which there has been no consent to jurisdiction. The Law of the Sea Convention itself is the instrument that contains the consent. Now, as to where you go, if they want to, states can make a declaration on choice of forum under the convention, but if, like both China and the Philippines, they opt not to do so, then the convention says explicitly that they're deemed to have accepted arbitration in accordance with Annex 7. Now, Article 9 of Annex 7 provides in part, and I won't bother you with the full text, that the absence of a party or failure of a party to defend its case shall not constitute a bar to the proceedings. If they wish, as I indicated before, states may make a declaration excluding compulsory jurisdiction over certain types of disputes that are enumerated in Article 298. China made a declaration excluding jurisdiction over all the types of disputes set forth in Article 298. Going beyond that, the Convention expressly provides, this is not unusual, in the event of a dispute as to whether a court or tribunal has jurisdiction, the matter shall be settled by decision of that court or tribunal. Finally, Article 296 of the Convention provides, and I quote, any decision rendered by a court or tribunal having jurisdiction under this section shall be final and shall be complied with by all the parties to the dispute. I only add to this that Article 300 specifically says that states parties shall fulfill in good faith the obligations assumed under the Convention. That then, very quickly, is the textual background, and of course it's therefore the textual material with which both the parties and the tribunal had to work. As you all know, China did not exercise its right under Annex 7 to appoint one of the 5 arbitrators and to join with the Philippines in selecting 3 of them. In that situation, the Annex expressly provides that the President of the International Tribunal for the Law of the Sea shall make the necessary appointments, and the result, as Mr. Reichler pointed out, was an expert, experienced, and exacting panel of extraordinary distinction. China also declined to participate in the proceedings. But that said, as Mr. Reichler pointed out, its foreign ministry and other officials commented publicly on certain issues, and some of those statements were transmitted by China's ambassador in The Hague to the members of the tribunal, either directly or through the registry of the Permanent Court of Arbitration, each time with the caveat that this did not mean China was participating in the proceedings. This included the lengthy position paper that Mr. Reichler referred to, which the tribunal decided to treat as a plea on jurisdiction. The same kind of step was taken in the Arctic Sunrise case with respect to the statements made by the Russian Federation, which were also treated as a plea on jurisdiction, even though Russia was not participating. Now, Mr. Reichler went through 2 of China's 3 basic objections to jurisdiction set forth in its position paper. The first was that the dispute at its heart was about territorial sovereignty over the features in the South China Sea. As you all know, the Philippines expressly excluded that from its submission of the dispute. I would add only to what Mr. Reichler said that the tribunal, in indicating its disagreement with that jurisdictional objection, made the following observation, which I would think would be some source of satisfaction in Beijing, when it said, and I quote, that it is entirely possible to approach the Philippines submissions from the premise that China is correct in its assertion of sovereignty over Scarborough Shoal and the Philippines, unquote. I was quoting from, and the Spratlys, excuse me, unquote. And I quote, no, sorry, I appreciate that. And that was on the first point. On the second point, China did argue that the Philippine agreement in the so-called Declaration of Conduct and in other instruments to negotiate the dispute, in effect, constituted an agreement to exclude jurisdiction under the convention. And in this respect, I just want to point out the tribunal found that the Declaration of Conduct was not a legally binding instrument, and that none of the other instruments examined, and by the way, the tribunal examined more instruments than China itself had cited, precluded resort to the convention's compulsory dispute settlement procedures under Articles 281 and 282 of the convention. And then the third point was mentioned by Mr. Reichler, and that is that this was a delimitation dispute. And again, the tribunal found that you could deal with entitlement without getting to the question of delimitation in areas where the entitlements overlapped. Although China did not raise the question of absent parties, and in some respects the most notable absent party would have been Vietnam, the tribunal considered the issue and held that third-party claimants were not indispensable parties. As some of you may know, you had all of the potential third parties sitting in the room as observers, and the tribunal did note that none of them had raised the question in the ordinary course of the proceedings with respect to this third-party claimant. Excuse me, is there?
Where does Taiwan fit?
Taiwan does not fit in there. Taiwan is not a party to the convention. It will doubtless be of some solace to people in Taiwan that the United States of America requested the opportunity to attend the proceedings as an observer and was not permitted by the tribunal to attend on the grounds that it was not a party to the UN Convention on the Law of the Sea, right? That is perhaps a less interesting one than one other state that requested the right to attend as an observer, was granted the right, and then chose not to send an observer, which is not the situation the United States was in. I should note in Vietnam's case that Vietnam delivered, some of you may find this interesting who are arbitration experts, Vietnam delivered a statement of position to the tribunal. In that statement of position, Vietnam stated that it had no doubt that the tribunal had jurisdiction. It would be very difficult to reach the conclusion that Vietnam considered itself an indispensable party if it made such a statement. Vietnam also took the occasion to disagree with the key Chinese substantive claims.
I should point out that we invited the government of Vietnam to have a speaker here, but after a long period of hesitation, it has declined to have somebody speak here.
Yeah, in that vein, let me add, Vietnam's statement reserved the right to intervene in the proceedings, but Vietnam never did petition to intervene.
I should also point out that we thought we were going to have a representative of the Philippines here, but no authorization for his appearance has been received, and it shows the sensitivity of what seems to be. It shows the sensitivity of what seems to be going on, that both Vietnam and the Philippines prefer to maintain silence, at least in this kind of a forum. And I try to be hopeful in the inferences I draw from that.
China also did not invoke the optional exception to jurisdiction for disputes concerning military activities. That exception was covered by its declaration under Article 298. Nevertheless, the military activities exception was held to apply to the Philippines submission concerning the standoff at Second Thomas Shoal between Philippine military forces and a combination of Chinese military and paramilitary vessels, and I quote, arrayed in opposition to one another, which the tribunal considered, and I quote again, a quintessentially military situation. I would not be surprised if that particular finding was greeted with satisfaction by people both in the People's Liberation Army and in the Pentagon. On the other hand, and here I quote, this is interesting, the tribunal will not deem activities to be military in nature when China itself has consistently resisted such classifications and affirmed the opposite at the highest level, unquote. Accordingly, the tribunal did not apply the military activities exception to the submissions concerning China's construction activities, and it noted that China had repeatedly stated that the facilities it was building in the Spratly Islands were intended exclusively or primarily for civilian use. In this regard, I note that shortly before the hearing on the merits in this case, President Xi Jinping stated at a White House press conference with specific reference to China's construction activities in the Nansha Islands, which are the Chinese name for the Spratly Islands, that, and I quote the President, China does not intend to pursue militarization, unquote. No, Spratly, Nansha Islands. The statement says Nansha Islands. Okay. I certainly hope so. The same clause of Article, actually, Melissa, is that right? Oh, yes, okay. The same clause of Article 298 that permits declarations excluding disputes relating to sea boundary delimitations, and remember China did evoke that, also refers to those involving historic bays or titles. And China's position paper did not invoke the latter exclusion. The tribunal nevertheless considered whether the latter exclusion applied to this case. And in doing so, it distinguished the reference to historic title in Article 298 from a broader notion of historic rights. And it interpreted the exclusion for historic title to refer to claims of sovereignty, noting the association of claims of sovereignty with things such as internal waters and the territorial sea. Both are close to shore, and both are subject to the full sovereignty of the coastal state. After a very detailed examination of the text of Chinese laws and assertions, including China's affirmation of freedom of navigation and overflight in the South China Sea, to which Mr. Reichler adverted, the tribunal found that China asserted historic rights within the 9-dash line encircling much of the South China Sea, but it did not claim historic title over those waters. And accordingly, the Article 298 exclusion for historic title did not apply. To that background on the jurisdictional issues, let me add one thought, which could basically be, if that, a footnote to what Mr. Reichler has said at greater length. China continued to rehearse its jurisdictional objections, notwithstanding their rejection in the award on jurisdiction. It has now adopted a very similar posture regarding the award on the merits. That may continue to be its official response to any invocation of the award, at least for now. Over time, they may well take into account the points raised by Mr. Reichler, and I would certainly be among those who would hope so. Both now in the near term and in the longer term, the award's actual impact on perceptions and behavior is a different matter. One would not, for example, argue that the award as such is legally binding as between states other than China and the Philippines. Yet the perceptions of those that border and use the South China Sea, and indeed the seas and oceans beyond, will unquestionably be affected by this authoritative contribution to the law of the sea and its application to one of the world's most important seas. Let me stop there.
I see that despite my respect for procedure, I have violated the procedure of this meeting by neglecting to see that my colleague, Peter, is supposed to moderate.
I'm perfectly content to continue as we are. Sure. Well, Dr. Hong Nong, we would love to hear your thoughts on the jurisdictional issues. But beforehand, in case you don't know Dr. Hong Nong, I've long known her, and it's been a pleasure to know and work with her, just as I've long known and admired, actually, Bernie Oxman's work. So Dr. Hong Nong comes to us from Washington, D.C., actually having worked for Wu Shuotsun at the National Institute of South China Sea Studies, both in Hainan and in Beijing. She's currently heading up an institute in Washington called the Institute for China-American Studies, and she's followed this issue very closely because, in part, she has a professional interest, but she's also gotten her doctorate from the University of Alberta in the intersection between international politics and international law. So it's on that basis I think we'll hear from her now. Thank you.
Thank you, Peter. What an introduction. Thank you very much. And thank you to Professor Jerry Cohen for having me, including in this very important group of people. And I really appreciate that. To be honest, when you asked me to speak about from a Chinese perspective on jurisdiction issues, it's quite a challenge to speak at a position which is totally opposite to a very strong legal team where we see Mr. Reitler and also after, especially Professor Oxman, who I respect highly as a student of law of the sea. So it's quite a challenge. But I do believe that China's position on this arbitration case deserve a better understanding. So before I come to the issue on why China questioned the jurisdiction and admissibility, let me start by providing some observations. I think at this moment, at least there are at least 5 misleading narration about China's position or China's attitude towards international law and China's position on the third-party compulsory dispute settlement mechanisms. So the first misleading narration is about no participation does not equal to not respecting international law. So if we look at Chinese state practices on international law, we can see there has been very actively passing many of the international conventions, regional conventions, and regulations. And as Mr. Reitler has pointed out in his opening remark, if we look at Chinese state practice in commercial arbitration, it has been very frequently utilizing the dispute settlement mechanism of WTO. That's explain that Chinese position, a very active participation in international law. And also, if we look at Chinese state practices of its negotiation history on land boundary, we see that it has already accumulated very rich experience in terms of solving the land border with its neighbors. And also, if you look at we have a review on China's negotiation practice with Vietnam in the Gulf of Tonkin, which is the first maritime and the only maritime boundary so far in the South China Sea. We see that where China has its own reason and its own experience of dealing with international dispute with its neighbors. And this is one of the first misleading narration I want to point out. And the second issue, often we hear about that the South China Sea arbitration is one of the examples showing that small neighbors, small countries utilizing international law in preserving or protecting its national interests. But China was pictured as a big power in this region. But I would rather say that, well, before international law, no matter how big or how small the country is in size, and they should be equally treated as a state in front of international law. And the third point is about the role of international law in dispute settlement. I think as a student of international law, it's always very important to not to underestimate the role of international law. But sometimes if we put the international law or also state practice in the regional context, we might not see how it goes at its design. For instance, if we look back to the past 3 years, and with this arbitration case going on, we do see sort of suspension or the delay of many of regional cooperation or initiative and very good proposals. So the ongoing disputes and the emphasis on maritime disputes between China and other claimant states has been overshadowing many of ongoing discussion between China and other claimant states, including ASEAN as a whole in terms of fostering regional cooperation in this region, which is a very important spirit under Article 1 and 3 of UNCLOS. And the discussion on Article 74 and 83 on the pending maritime delimitation, all the countries should be encouraged to resort to contemporary arrangement. And those discussion has been also overshadowed by the emphasis on the maritime disputes in this region. So as a matter of fact, sometimes we see the very positive role of international law in maritime dispute settlement, and sometimes reality, very unfortunately, and we might see that the emphasis on the compulsory dispute settlement sometimes might have a negative impact on regional cooperation. And the fourth misleading narration is about the Article 298. We hear very from Mr. Rachel and Professor Oxman. I think the 298 article is very important. It shows it's one of the it's one of very good examples. Shows that the Law of Sea Convention, the package deal, that in order to achieve something, you need to give up something. I think 298 gives a country's right to exclude those disputes which they consider as very vital to their national interests from a third-party forums. So in this case, you can see that although, China has strongly argued on Article 298, but with a very strong legal team, and then we see that countries may play around Article 298 in the future. So I do worry about for countries who does not want to give consent on, for instance, sovereignty issues, maritime delimitation issues, law enforcement, maritime or military activity issues to a third-party forum, they might need to reconsider the essence of Article 298. And another issue that comes to my mind is about Article 287. And when we study law of the Sea Convention, as Professor Osman pointed out, there's different orders. The ITLO rate as the first one, and then followed by the ICJ and Arbitration Tribunal and Special Arbitration Tribunal. So we see the artisan right case, and which is also a very good example of utilizing the Annex 7. And this South China Sea arbitration case is also another example which might explain the future. Maybe more and more countries will prefer going to arbitration rather than going to ICJ and ITLOs. And partially because not to be too defensive, compared with ICJ and ITLOs, we see a comparatively low threshold of passing jurisdiction admissibility. So this is some question about general concern about the future development law of the convention. And the last point I want to make with regard to China's position towards international law is on how China interpreted the law of the sea as a treaty law and how China comply with customary international law. So I think there's a lot of misleading understanding or perception about Chinese claims. Well, I think Chinese claims very simple. Claim sovereignty over those features according to customary international law, such as principle territory acquisition. And then because ratified the Law of the Convention in 1996, then it will claim maritime jurisdiction based on Law of the Convention. And then there is a very important issue that we see from Paul's map. There is overlapping area from the equidistant line, between equidistant lines and then a U-shaped line. We see this overlapping zones. And I would say that where China claims, although not officially that China has made a statement they claim the historical right, but oftenly I think many of the mainstream scholars in China argue that China claims historical right, but not on an exclusive basis. Rather, I think China's claims based on non-exclusive basis, meaning that, when China say we have jurisdictions within the U.S. according to traditional fishing right, for instance, we are ready to provide legal and also legal evidence. And if other countries in this region, such as Vietnam, the Philippines, or Malaysia, when they are also ready to present their legal evidence, historical evidence, then this kind of historical fishing right should be based on an inclusive basis, meaning all the countries, they should have their rights for exercising historical rights as long as they can present their legal and historical evidence. And then the question is also about how to treat the relationship between the treaty law, which the Law of the Convention is a very good example, and how to treat the role of customary international law. I think Chinese claim based on Chinese claim over historical rights based on customary international law. So we should not overstate that China's only resort to the Law of the Convention in interpreting its maritime claims in the South China Sea. Then I would like, so this is a very general observation I would like to share with you in order to clear some misperception about China's attitude towards international law and the Law of the Convention. Now, coming to the question of jurisdiction, and Professor Osman has laid out a very good foundation on why China question about the jurisdiction issues. So let me emphasize a couple points, especially the skepticism about jurisdiction issues. The first one, I think in order for a tribunal to be set up, the two countries should have a dispute or a legal dispute. So from the Chinese perspective, the disputes between China and the Philippines is not concerning interpretation or application of Law of the Convention. If we talk about the historical right, for instance, in the submission 1 and 2, and then for that particular, then we have to resort to customary international law rather than the Law of the Convention. This is the first argument. And the first one, and also the second argument is, for instance, in the submission 3, 4, 6, and 7, and the Philippines asking the tribunal to define the legal state of several features, including scabrous, mischiefs, second commercial, etc. And then I have to say that from Chinese perception, we don't see there's a difference in interpreting the legal status from the Philippines, because from the Philippines submission, you're asking the tribunal to define individual features, defining the legal state of individual features. But for instance, Trevor never say that China is going to claim Scabrous as an island, and Trevor never say that we're going to take the second commercial, for instance, as an island. So from that perspective, we don't see a real dispute or real legal dispute between the China and the Philippines. And this is only one of the very few, one of the many examples that we thought between China and the Philippines, there is no real dispute. And certainly concerning Article 281, and China referred to the 2002 Declaration of the Parties in the South China Sea as one agreement, although it's a political document only without legal binding forces, but China regard this document as one document showing that China and all the ASEAN member states, including the Philippines, has agreed to resort to peaceful means of settlement in a dispute in the South China Sea. And particularly, I think about Article 283, and the tribunal argued that the Philippines has substantially exchanged views with China. But from China's perspective, if you look at the previous negotiation history, what has been exchanged between the two countries is mostly about the sovereignty issues and relevant maritime delimitation issues, rather than a legal status for these features that were stated in the Philippine submission. So through the negotiation history, we never talked, Philippines has never brought this issue up to China that they are going to apply, for instance, legal Article 120Y of those features in the spot list. So 283, according to China's perspective, has not been fully exercised by the Philippines before it goes to the arbitration tribunal. And certainly, there's also question about Article 298. And it's very true that in the Philippines submission, it tried to delink its submission with sovereignty issues and also with maritime delimitation issues, but without defining who owns what and how could you define who is the coastal state. So many of the following submission in the Philippines memorial, for instance, about whether China has been illegally violating the Philippines' rights, especially on, for instance, has been prohibited, for instance, the Philippine fishermen, all those law enforcement issues without defining who is the coastal state. And how could you actually define who is exercising the law enforcement activities? So those are the argument that China brought forward in its position paper, and also you can find very many of the substantial professional legal writings for the last past 3 years. And also, well, but having said that, personally speaking, I am not totally entirely opposed of the jurisdiction issues by the tribunal, especially on Article 121. I do believe the tribunal has jurisdiction issues on defining Article 21, although on the merit issues, I'm not totally convinced, especially on the island of Taiping and Itu Harbor. So I think my last point is that although having expressed Chinese position, which I also personally agree with most of it on the jurisdiction issues, I do want to say a few words about the implication of arbitration case in the South China Sea, not necessarily always negative from Chinese perspective. For example, I think Mr. Reichler made a very good point in his final remark. So we take the arbitration case as a lesson for China in rethinking its future policy options in addressing its maritime dispute with its neighbor. So it's a very good opportunity for China to learn a lesson from. As a matter of fact, and maybe there was a misperception that China does not appreciate the value of third-party forums. But if you are within the academic circle in China, we always hear different views. There is not always one single view standing in favor of the government position. We often hear different views, and especially many young scholars, they are really working hard to write academic paper about the jurisdiction issues and questioning about the merit issues. So we see a booming group of young scholars who study to take the Law of Sea Convention as a career in the whole domain of international law. We used to see a lot of international law students in China. Normally they would pick private international law or commercial law as their major, but after this arbitration, we do see a booming interest of young scholars who want to develop career along the path of the law of the sea. So I think it's a very good opportunity for China to rethink in its future about what might be the best policy option for its future. And we do see, although China officially said there's no way that's going to comply with the award, given the reason they explained on the jurisdiction issues and on many of the issues on the merits. But I do think that the arbitration case has a role in helping speeding up the regional negotiation. We see progress on the COC, and we see that China and ASEAN have agreed to use or apply the CUS the code I'm playing encountered at sea as one of the regulations that China and ASEAN has agreed to apply in a good way of avoiding accident at sea. And we also see a lot of ongoing discussion on functional cooperation. So I'm not quite sure whether we should give the credit to the arbitration case, but it's a very good timing for China and ASEAN countries to pick up the discussion on functional cooperation. So for the last 3 years, we see kind of a suspension and delay of all these very good regional proposals on functional cooperation. But with the end of the arbitration case, I think all the countries step a little bit backwards. For face saving for all these countries, and also they are also considered that's a very good timing for them to pick up discussion on on functional corporations and on a variety of fields. And to echo what has been discussed, I think we all learned a very good lesson from arbitration case, whether it would be considered as a pros and cons. We see the two sides of our coins. So that's what I want to share with you about the jurisdiction issue. Thank you.
Well, now we've heard three, frankly, really wonderful presentations, and I'm pleased that as many as possible will be online and available for us to reflect on because there's so much there to work through. With your indulgence, Jerry, I'm going to lay 5 issues on the table for general discussion, and then I'd like to have more discussion from around the room. What is it that's on your minds as you listen to these really excellent presentations? I work at the intersection of law and policy, and so the observations I will be making have to do with some practical questions. And I invite all of the experts here at this table, but certainly beginning with Professor Oxman and Hong Nong to tell us, to give us some reasons why I'm wrong, to worry about some of the things I worry about. The first has to do with essentially what the convention, as Hong Nong has just been describing to us, attempts to balance in terms of sovereign prerogatives and the importance of international dispute resolution as a compulsory matter. Mandatory dispute resolution was deemed to be essential to the success of UNCLOS, and yet we do know that this has really been a difficult issue for China. The first question I'd like to lay out is, did the tribunal's ruling capture the spirit of this balance effectively? Or is it time to sort of reflect on whether 298 goes far enough when essentially the international community just says to China, well, look, you signed it. It said that you could be taken into a mandatory dispute resolution process regardless of your objection to it. Is that a sufficient balance of sovereign prerogatives with dispute resolution? The second perspective I'd be interested to hear your thoughts on is and I need to say this, which is that these views I'm speaking of now are my own views, not the representative views of any agency of the government. I'm responsible to say that because I'm a government official. But the second has to do with a practical problem. When there are, in fact, overlapping exclusive economic zones or other claims, but here are exclusive economic zone claims, where each state genuinely believes it has a right to enforce its own law in a specific place. Here, what we've observed is that there's essentially a post hoc condemnation of the behavior of one party that genuinely believed, and in fact, this was recognized by the tribunal in paragraph 704, the tribunal noted that China was in fact acting on a good faith belief in its rights in the South China Sea. So was this in fact, this sort of post hoc condemnation, appropriate? Or might a more restrained approach have been, rather than to take jurisdiction over actions in the past, to give a clearer statement of entitlements, expecting future action to be in compliance with them? You might say that that's really a distinction without a difference, but in some ways it really is, because the awards have a political effect, right, on giving China some face and some room to maneuver in negotiation. So in the end, we have to ask, are undelineated exclusive economic zones essentially to be treated like high seas, where no side has a duty to, or has the right to enforce its laws? We know that there are duties to cooperate, but we also know duties don't always result in cooperation. So how should they be treated in light of the decisions here? The third point I'd like to raise has to do with the existence of traditional fishing rights. It's a related point. They were just adjudicated at Scarborough Shoals. Was it wrong for Chinese law enforcement in acting in what it believed good faith to enforce sincerely held state perspective of its entitlements at Scarborough Shoal? Did the tribunal overreach in its jurisdictional finding of fault on these past actions rather than simply prescribing future actions? The fourth point I'd like to raise is related to military activities. This is a somewhat different question. The court decided that Article 298(1)(b, that's the authority of China, if I'm getting that provision right, the authority of China to accept military activities from the tribunal's jurisdiction was not implicated. In two cases in particular, Fiery Cross and Hughes Reef, where it was really quite clear, even from the evidence that the tribunal observed, that there was military construction involved. The question that is left with is, did the tribunal here overreach in its jurisdiction by taking at face value China's political statements that these were not military activities, when, well, had they asked any military authority outside of the tribunal, the answer would have been, of course, those are military activities in terms of just creation of a military base. So it seemed a little quick to exercise jurisdiction here, and it seems to me perhaps this is a case where good facts make bad law, in the sense that there was a real justifiable outrage at the Chinese actions that resulted in the just obliteration and destruction of the reefs and the environment in the area of these islands. But perhaps because these were in fact military activities, maybe the court should have exercised restraint in order to have a more restrained approach in future cases where maybe the call is a little closer. And then the last point I'd like to raise, again, is the question of exercising its authority over law enforcement activities in relation to the question of the entitlement of the exclusive economic zone or not around Ituaba, Taiping Island. One of the things that it struck me as I was reading the opinion, I was really quite surprised in reading the opinion that the tribunal did not even attempt to look at state practice about how states around the world attempt to interpret Article 121.3 for themselves. Now, I have just begun, this is a long study, but I've just begun to compile evidence that the United States and Japan and Australia and New Zealand and France, and this is just in the Pacific, all have claims that might be called into question given the current tribunal's approach to the matter. Now, let's think about that, right? So these, 1, 2, 3, 4, 5, plus PRC 6 states, each of which participated quite actively in the negotiation of the convention, if they interpret Article 121.3 in this particular way, might that not be an important factor for the tribunal to consider in its understanding of Article 121.3? In other words, did the tribunal place its judgment about the law? Did it replace its judgment about the law with the judgment of the states that actually negotiated the law in the first place? So how are we to address now this gap between state practice and the ruling in the future? And here's an important point, right? Because if other states, important states in the international system, reject one aspect of the ruling, does it give China more room to legitimately reject the ruling in its entirety? So these are just some things I wondered as I was going through the opinion. It's 500 pages long, and I think truly it'll be a decade or more before we've really sorted out, we the international law community, have sorted out what these issues are and how to deal with them, and did the tribunal get them correct? I'm not saying that I have it correct, but I am saying these are the questions I had as I was reading through the opinion myself. And I invite comment first from the table, and then what we'll do is we'll take questions from the floor. What I think we'll do from the floor is we'll take 2 or 3 questions at a time, so be thinking of them now, and then we'll put them on the table as well. Gentlemen, ladies? Bernie, did you have a desire to weigh in?
Desire would be an overstatement.
Well, it's perfectly fine if you say phooey. You're wrong on all these counts, but it's just my question.
Let me iterate that the one statement you made that I was absolutely delighted to hear, in light of the nature of your questions, is that they do not necessarily represent the views of the United States government.
Fair enough.
But this is an important point. I think that if that approach to the law of the sea were to prevail, it would seriously prejudice the interests of both China and the United States over the long term. And I want to emphasize, there's an underlying approach in these questions that I find troubling. But then let me go through these questions one by one, as I understood them. The balance between the autonomy of states, I don't like using the word sovereignty, which loads the discussion. The balance between autonomy and subjecting the behavior of states to compulsory dispute settlement is, of course, a difficult one, and I entirely agree that the convention represents a very careful attempt at a very, very careful balance on this question. I think that this tribunal very carefully attempted to respect that balance. I do think, however, that there would be appropriate targets for your question that would raise the issue in other ways, including the arbitral award in another case that Mr. Reichler won in the Chagos Island dispute, where I think that the tribunal went quite far, although in a way I have to say that might please many people in this country, but I think it went quite far. But I don't think it did in this case. And let me emphasize that although China did not raise the military activities exception, this is one example, the one situation in which the tribunal found that a submission by the Philippines was not subject to the jurisdiction of the tribunal was based on the military activities exception. Second, and I think this is important, the letter from the Philippine ambassador transmitting the Chinese position paper stated that the position paper was comprehensive. The Philippines did, in fact, argue that because of the statement that it was comprehensive, that we should consider basically the objections that were expressly made by China as what would be considered. And the tribunal did not accept that position. It considered all of the possible objections to jurisdiction, and indeed the Philippines had addressed all possible objections that it could think of in the memorial because it had been instructed to do so. So I think this was a tribunal that was very careful on the matter. As to overlapping EEZs and condemnation of conduct, there was no condemnation of prior conduct. There was no claim for damages in this case. The simple statement was whether there was or was not a violation of the convention. When states have different legal positions and they go to court, you know, one, not necessarily on all issues, but one is going to prevail on an issue and the other is not going to prevail, and you're going to get a declaration as to who is right. But I would not read this as a condemnation, and indeed the paragraph that you cited stating where the tribunal made clear that it felt that China was taking its substantive positions in good faith, I think illustrates that. As to traditional fishing rights, I found that very interesting. China, of course, had not pleaded in the case, and therefore, while it had issued statements that it had historic fishing rights in the area, and that had appeared in Chinese scholarly works as well, the tribunal reaches a conclusion, even with China not having made the argument, that both Chinese and Philippine fishermen, over a very long period, of time in the territorial sea had developed historic fishing rights and went out of its way to say that if the situation were reversed and the Philippines were in physical control of Scarborough Shoal, then the Philippines would be obliged to respect the traditional fishing rights of the Chinese fishermen. This is a very, very interesting underlying analysis. I have to say that from the perspective, putting aside this dispute, from this perspective in many parts of the world of small artisanal fishing that has gone on from generation to generation to generation, that the tribunal saying to states, you know, we don't care which of you is in control. You can't just trample on that situation. You have to have some respect for it. And yet the tribunal was careful to say that the regulatory power of the coastal state remained. Of course, there's an issue as to legal issue as to which is the coastal state, but there it stood. As to your point on military activities, I read the opinion as very clear, and that is the tribunal said that it will not conclude that an activity is military when China has repeatedly stated that it is not military. And I do not think you can ignore the fact that several weeks before the hearing on the merits, the head of state of China, standing on the White House lawn, makes a statement that China does not intend to militarize the Spratly Islands. This is not a common law tribunal that is driven by positions of the parties in the way a common law court is. But when the parties themselves are not taking opposing positions on an issue, when a state declines to have its own activities characterized as military, and when there are consequences to characterizing activities as military that a state, for whatever reason, chooses not to confront, and when the state, I have to add here, that says the activities are not military is undermining any jurisdictional argument that could be made in its favor. In other words, this was not an argument in interest, but an argument against interest. I think that looking at this question as a question of litigation management, if you will, you get an entirely appropriate result. I think the result that would have looked truly odd would have been a disagreement with the characterization of the activities by the head of state. There is, of course, a precedent here. It's not the same kind of a situation, but international lawyers know that while the original nuclear test cases of Australia and New Zealand against France were underway and France had refused to participate in them, that while the proceedings are going on, the French president makes a statement that this is the last set of nuclear tests. Now, you know, at that point, we all know the outcome, and that is the International Court of Justice mooted the case and said, well, there's no dispute anymore. And once again, when a head of state makes this kind of statement, you have to know that the head of state, in fact, has been briefed full well on what the legal and other contexts are. The question of state practice is an interesting problem. State practice was presented. Now, you have to be very careful about state practice. The entire crisis in the law of the sea that leads to the UN Convention on the Law of the Sea is by this misunderstanding of state practice, that state practice is claims by coastal states, full stop. That is not what state practice is. State practice is what happens when disagreements emerge, right? And simply claiming rights for yourself doesn't fully complete the equation, at least where there are objections. The most eloquent invocation of Article 121.3 that emerges in state practice and which is quoted in the award is the absolutely brilliant Chinese notes challenging the Japanese claims in respect of Okinawa-Tokushima. The reason I say they're brilliant is China was faced with a jurisdictional problem there that Mr. Harris is doubtlessly familiar with. The same commission had refused to read the United States objections to the Brazilian submission on the grounds that the United States was not a neighboring coastal state to Brazil. And when China submits its objections to the Japanese submission, the Chinese lawyers doubtless knew that they were faced with a similar kind of problem, although they didn't advert to it. And if you read the Chinese note very carefully, it is a very, very strong argument in favor of the proposition that all states have the duty to see that Article 121.3 is properly presented. China also emphasized in its very well-written note that this all depends on the feature in its natural condition, not what states have done to it since the natural condition. Now, the tribunal didn't decide the Okino-Torishima question, and I am not proposing here a solution to it. Japan was not a party to the case. But the fact remains that where you did have a dispute, you had a state practice which goes two ways, and the tribunal was clearly well aware of it. You have Japan making the claim, you have China and Korea, for that matter, coming in and contesting it. What more you have in terms of state practice is an odd problem, and that is you have states declaring exclusive economic zones. Sometimes it's clear, sometimes it's not clear as to whether those economic zones are intended to extend around very small features. But that's where matters stand. And this case was not one, I do want to emphasize this, in which you had a clear maritime claim sitting around for a long time with nobody saying anything. It was the exact opposite, as the tribunal points out. China makes its maritime claims clear in the 9-dash line maps, and you have an immediate response by the other states, not only to the 9-dash line, but an express response on the islands question in some of the responses, including, for example, that by Indonesia. You could argue that in other situations there is arguably a different question. I also would be cautious here. All of these features are very small. You mentioned Ituaba, which is the very largest of the Spratlys. Ituaba is less than a half square kilometer in size. And that's why the tribunal held, and I think rightly, that the word rocks doesn't necessarily mean something that's geologically a rock, and its reasoning there, I think, is very sound. It's, you know, you can't jump from there to very, very sizable articles. So that I think the underlying assumption that state practice was not considered would have to be modulated substantially.
Great, thank you. Well, let's give Hong Nong a chance just in case. Do you have something you'd like to say?
Professor
Yeah, please do put your
Osman
cards
has
up.
addressed I think all of your questions, but I would like to pick up only two. The first one, very briefly, I do have huge difficulty to understand the tribunal's decision to recognize traditional fishing rights in the territorial sea of Scarborough Shoal, but deny China's traditional fishing rights in the EEZ. I feel it's very difficult to understand what's the criteria of defining the traditional fishing rights. Normally, in the territorial sea, a coastal should be granted more, it's like solid sovereignty, and in the EEZ, then you have less compared to the territory, less sovereign rights. I don't see the criteria that has been chosen by the tribunal. And then also, Peter raised a question whether the tribunal has expanded jurisdiction, and I also find it's very hard to understand. In its 500 pages long ruling, and there is 1.5 pages, not necessarily very long comparing to its interpretation of 121.3 and other, for instance, submission 1 and 2. This 1.5 pages, the tribunal decided that it's going to deny China's rights to use the Spratly as one single unit to claim under Love's conventions. I'm not arguing in the merit of this decision. The question here is that in the Philippine submissions, and there was not such a submission asking the tribunal to define or rule about the possibility of archipelago regimes, application of archipelago regimes for a continental state. I don't see why the tribunal expand its jurisdiction and to go over these questions. And I think I would like to very briefly respond to the state practices. I think the South China Sea, we could not find a better case than the South China Sea if we want to consider effectiveness of Love's Convention as a constitution in providing maritime order in the maritime domain, because it almost covers all these issues listed in the Love's Convention, and also like coastal state, usual state, archipelago state, and then littoral state. Straight state. So there's never a better case. But the Love's Convention itself does not address all these issues. And when I talk about the state practice, I will also refer to the efforts by the coastal states in ratifying or passing many of the international conventions on the very diverse fields. Like, for instance, we have the SURE conventions on the maritime security issues. Then they also pass a lot of regulations on fishery management and also on the maritime environment protections. So we have to depend on the efforts of coastal states in passing international legislation in line with the Love's Convention. I think that's what I refer to. Thank you.
All right. So I'll let Paul go first, and then down to Admiral McDevitt, and we'll work our way down the table.
Well, first thing I want to do is compliment Dr. Hong Nong on her presentations, particularly the first one, because that really addresses where we go from here. And I think that the cause for hope that I tried to kindle in my remarks, I feel encouraged by what I heard Dr. Hong Nong say. And I think it's important to point out that this is, I was careful in my remarks not to say that in order to fully comply with the rule of law, with the convention, with the arbitral award, China must say, we are complying. We accept the authority of the tribunal and we comply. Of course, that would be very nice. It would be very helpful for promotion of the rule of law. But more important is China's willingness, consistent. I know Dr. Hong Nong doesn't speak for, is not here to speak for China any more than I'm here to speak for any other state. But willingness to consider the award as a path to a just and lasting settlement. Correct me if I am misinterpreting. I think that's very helpful and very, very hopeful. In regard to some of the specific points, Peter, that you raised, I'm going to defer to Professor Oxman in terms of his answers, but there is one thing that I want to add. On this issue of taking into account of state practice in how states interpret Article 121.3 for themselves, I do disagree with the premise of the question, because I'm fully aware that the tribunal did take account of the practices of various states, including China's practice with regard to Japan's claim on Okino Torishima. But what the tribunal was focused on in its interpretation of the text and also the object and purpose of Article 121.3. And I'm going to leave aside the question of how they applied it to particular features. That's the subject that this panel is going to discuss after the break. But in terms of the question that you raised, the tribunal was very clear in its understanding, and I think it's correct understanding, that the purpose of Article 121.3 was to prevent against excessive or exaggerated claims by coastal states, and therefore to prevent encroachment on the common area. Common area for humanity, the word is mankind, I prefer to use the word humanity, for humanity, but that this is what the tribunal understood to be the object and purpose of 121.3, and I would say it understood that object and purpose correctly. Now, how you apply it to a particular insular feature is something that we can discuss. But if you take a look at the state practice that you mentioned, I know I'm going to anger Bob Harris here, but my job is to be an international lawyer regardless of the country of my citizenship. And the United States makes egregious and outrageous claims for 200-mile entitlements from Baker and Howland Islands in the middle of the Pacific. They make Ituaba look like Manhattan. I mean, so these are completely indefensible claims. The United States is not the only one that's off the charts in asserting claims that are clearly in violation of the object and purpose of Article 121.3. And I couldn't even get him to smile. I told you he'd be angry. But but Australia is just as bad. France is just at Matthew and Hunter Islands in what used to be called the Hebrides. Now it's part of, well, it's contested between Vanuatu and France. But these are completely uninhabitable, tiny volcanic features also in the South Pacific. And as Professor Oxman said, state practice is not limited to outrageous and excessive claims made by certain big states that have the power to make other states at least not infringe. So I think the tribunal was duly circumspect. While it did consider state practice, it did not want to be bound by a reinterpretation or contrary interpretation of Article 121.3 because certain states have gone way out of bounds in making claims. One other point I do want to make. I think it is important and educational and that we here and in other fora undertake the academic exercise of analyzing the tribunal's award and debating whether we agree or disagree with different aspects of it. That's a perfectly legitimate exercise. But I think it's also important, and particularly on the subject of jurisdiction, to emphasize this. Again, I can't entirely shed my partiality, even though I try. But I've been a practicing international lawyer for nearly 40 years. And I have tried to dedicate my life and my practice to promoting the rule of law in international relations and holding great powers accountable. I started with the United States in the 1980s, so I have no bias against China. I have enormous respect and admiration for China, its government, and its people. But what we need to recognize here as international lawyers and scholars is that the award is exactly that. It's a final and binding award, as are its findings on jurisdiction. The convention itself says that if questions of the tribunal's jurisdiction or competence are raised, it is the tribunal itself that has the authority, the competence, the jurisdiction to decide on its own jurisdiction. And that is a principle of general international law that was put into the convention. It's not something that was invented by the framers. That is a very basic fundamental principle of international law. We can agree, we can disagree. Reasonable people can have different views about different aspects, whether the tribunal should have or shouldn't have. Perhaps if China had exercised its right to participate in the formation of the tribunal, there might have been other eminent international jurists and experts on the law of the sea on the tribunal who might have had a different opinion on some of these issues. But the fact is, as international lawyers, I think we're bound to say, yes, we can consider this academically, but the rule of law requires that we understand and accept that the tribunal has made its decision unanimously on jurisdiction. That is a final and binding ruling, and it is within their competence to determine their own jurisdiction.
Yeah, very important point, thank you, which is why I tried to phrase the questions in terms of implications. Jerry, you had a two-finger, then I promise you're next.
I have not seen photographs of the U.S. Features Baker and Howland, which I understand from Professor Oxman, we have by statute claimed to have a 200-mile exclusive economic zone. But I have seen photographs of the Japanese feature Okino Torishima. And it's ludicrous when you look at that feature, which is the size of a double bed, and think that that is entitled to a 200-mile economic zone. Now, you raise an interesting question. A standard is articulated by an international conference. Let's call it A. And then country one makes a ludicrous interpretation of what that standard means. And country two says, what? If they're going to do it, we better do it. And then 3, 4, 5, 6 countries all make totally ridiculous claims. Should that practice overcome the legitimate meaning of the standard that all countries had agreed to before? I mean, there are limits to what practice can do in telling you the true meaning. Here's the most self-interested, distorted application of Article 121.3. How can we take that seriously? I don't know. I'd love to hear from Professor Wang from Taiwan. So far, he has been too modest, and I hope he'll talk certainly in our
He's going to have to get in line, I'm afraid, but
Yeah.
because Admiral McDevitt's at the front of it.
Okay.
Well, happily, I'm going to make a comment on Article 121.3 on an implication for the United States. First, I need to say that I'm delighted that the tribunal came out with a clear, understandable litmus test or way to judge whether or differentiate between an island and a rock. But by doing that, I think it has made it even less likely that the United States of America will ever ratify UNCLOS, because it's not just Baker and Howland, it's Jarvis Island, Palmyra Island, Johnson Island, Midway Island, Wake Island, all of whom have a 200-mile EEZ, and I know for a fact that the Republic of Marshall Islands contests the one around Wake Island. And as long as we're not a party to the convention, we can't be taken to court like the Filipinos took China to court. And so as long as those things give us the right to either fish or turn them into national maritime parks, which essentially says nobody can fish in there, period, then we're never going to sign on, I think.
Thanks, Peter. I just wanted to respond to Dr. Hong's very constructive remarks and try and tease out some of the constructive suggestions you made on two counts. First, on non-exclusive rights claims within the U-shaped line. And I was wondering if you could just speak a little bit to what you understand to be the Chinese position on this, and what perhaps your own ideas are about constructive ways that this could lead to agreements among states. And I guess just to draw this out a bit, maybe you could think about in particular what the formula would be, for example, near the Natuna Islands with Indonesia, where we've had instances of Indonesian law enforcement trying to enforce law in their EEZ and having conflicts with Chinese law enforcement. And I wonder, particularly in that area where it's outside of 200 nautical miles from any Chinese features, what the formula would look like, whether or not it would look different, for example, in areas very close to shore, and maybe just walk us through how that might work. And then I guess maybe two other quick points. You asked a question about why the tribunal went beyond the questions of the Philippines to find traditional fishing rights in that area, but didn't find any similar rights in the EEZ. And I think the reasoning is very clear in the award, and I think it can also be inferred from the very concept of an EEZ regime, and perhaps Professor Oxman or Reichler will speak to this more eloquently than I will, but all states had traditional rights in EEZs prior to UNCLOS 3. There were no jurisdictional zones there. That's the reason why there could only be traditional rights in a territorial sea. So I don't think, and this speaks also to the question of whether or not there is a sort of non-inclusive, or rather non-exclusive or inclusive basis for Chinese rights in other states' EEZs. It kind of begs the question of why does China have superior rights to other states? Because all states enjoyed exactly the same rights in areas that are now EEZs. Those were all high seas prior to the convention. And I guess just a final point, and this one's more looking forward at what Chinese policy is likely to be. You asked about why the court, again, went out of its way to discuss archipelagic baselines around the Spratlys. And I think there are at least two reasons, and worth thinking about as China considers how to treat those areas in the future. They were asked about entitlements from the Spratlys, and they were considering all possible ways that the Spratlys might generate a 200 nautical mile EEZ. Individually, they deemed none of the features to be sufficient to generate an EEZ or continental shelf, and then went arguably in going beyond their mandate to take on board arguments that China had explicitly made. And if you look at Chinese law and statements, they're expressly called the Nansha Chundao, and there's a lot of different statements by officials that indicate that the Spratlys as a whole are considered some type of a geographic unity that should generate an EEZ. And so I think they went beyond their calling in order to take on board Chinese arguments and determined that there's no basis for drawing archipelagic baselines around anything but an archipelagic state. And I guess I've heard quite a number of arguments from Chinese scholars about different ways to shoehorn in archipelagic straight baselines around offshore groups of islands that are part of a continental state. And I wonder if you could speak a little bit to what the Chinese formula might be for such a drawing of baselines. Thanks.
Great, thank you very much. Hong Nong, we'll turn to you, but I do want to make one quick point, which is that the tribunal made a point of noting that the artisanal or traditional fishing rights are actually private rights, right? So it's a little bit different. They're not possessed by the state themselves, but by those historical fishing practices and those who have undertaken them, right? So it's just a distinction to be made, and it does help us to understand a little bit about why in the territorial sea as opposed to in the exclusive economic zone, those might pertain.
Well, there's one other point, it's a legal point, and that is in the section on territorial sea, the regime, in the Law of the Sea Convention, the regime for the territorial sea is subject to the convention and other rules of international law, whereas the regime in the EEZ and continental shelf is not. It's just based on the convention. And other rules of international law bring in to the territorial sea considerations customary or general international law, and in the Chagos arbitration, one of the findings was that this means that traditional fishing rights in the territorial sea are not inconsistent with the convention, but only in the territorial sea. That explains the difference.
At some point, I do hope we get to hear from Chris Mirasola, who's out in the audience and has done actually a very good study of this and published it as a law review article, even though he's only a 2L. Julian Koo, I think you're next. Oh, I beg your pardon. Yep, we have to get a response from Hong Nong.
Thank you. hopefully will not be too long. So as I raised 3 questions, let me start from the last one about the archipelago baseline. My question to both Mr. Reichler and Professor Osborne, well, is about the jurisdiction, whether the tribunal expand its jurisdiction, but I would like to address that as well. So my question here is that because the submission by the Philippines does not refer to this particular concept, archipelago, the Philippines only asked tribunal to define the individual features. And then the tribunal came up with a decision, this ruling on the possibility exclude China's future choice of like applying archipelago regime. Well, that's my question. But about the merit issues, well, it's not because that China, after the ruling, that China decided to re-emphasize position they're going to apply archipelagos, because even like before 2013, back in 2011, 2012, there was ongoing discussion about the applicability of archipelago regimes for outlaying mid-ocean islands group for continental states. So we, after looking at the state practice of many of the continental states, we kind of like argue that there was emerging international law. There is no prohibitions in Law's Convention that non-archipelago regimes, non-archipelago states will not be able to apply archipelago regimes in that state. So, but you're right, there is ongoing discussion, but China's position, which emphasizing on using or apply the whole Spratly as one single unit, does not come after the ruling. It has been ongoing discussion, although you won't see the official statement for the government. It's like that China has never given a public statement on the historical right. So it's kind of like policy option whether to make it very public. And the second question about the traditional fishing rights. You see, you're saying that when EEZ, it's a very clear regimes compare with territorial sea. But in the Spratly or in the South China Sea, there is not a final delimitation yet, meaning that there is no clear EEZ. So it's still well considered, still there's overlapping zones. So when we're saying traditional fishing rights in EEZ, I'm actually referring to those areas where there's a gap between the equidistant lines and the U-shaped line. That's why I'm questioning about why the tribunal decided not to exclude the traditional fishing rights in the so-called EEZ, which here I refer to the overlapping zones. And also I think I could refer to the case between Barbados and Trinidad and Tobago. And the issue of traditional fishing rights was also raised the issues, although the tribunal say that it's not going to address the issues in the war, but it does require the two countries to discuss the possibility of Barbados fishermen in exercising fishing rights in Trinidad and Tobago's EEZ. And then the first question about the non-exclusion right, and again, there is no official statement for the government, but there is an ongoing discussion among Chinese scholars that Chinese claim based on historical rights, especially to the fishing rights, should be non-exclusive.
All right, Bernie, you have a quick response?
Yes, let me quickly comment, since it seemed to have been directed to Mr. Reichler's comments and mine. First, on the traditional fishing rights, let me again repeat what Paul said. The exclusive economic zone regime in text expressly rejects traditional fishing rights. If you want the legislative history, one of the most vocal states in opposing the recognition or acceptance of any traditional fishing rights in the exclusive economic zone was China, which basically indicated, if you look at the record, that it was not going to accept any regime. China's view represented the view of the overwhelming majority of coastal states, and therefore the notion that everybody was fishing under the high seas regime before did not create traditional fishing rights. There was no discussion of that issue in the context of the territorial sea. The territorial sea regime comes out essentially the way it was in the 58 Convention, with a reference to international law. And as the lawyers here know, it was not just the Chagos Island case, but in fact Eritrea, Yemen, that talked about each case. I want you to bear in mind that the discussion is of inshore, very close to shore, artisanal fishing, which has been going on for generations by local people. And if you wanted, I think, to understand the underlying rationale, and I do hope some people will write on it, you probably have to start bringing in international human rights law, because that's what it appears to be about. You're quite right, Mr. Dutton, that they're addressing people's rights in that situation. As for the single unit, the point's been made. I completely agree. They considered the single unit argument with respect to the Spratlys because China's own statement said as a whole. The Nansha Islands as a whole generated exclusive economic zone and continental shelf. Moreover, they had jurisdiction because the Philippines claimed that China was unlawfully interfering with the rights of the Philippines in areas within 200 miles of the Philippines. If the Nansha Islands as a whole generated a 200-mile zone, or for that matter, if Ituaba only generated a 200-mile zone, then most of that Philippine argument disappears because you'd have a delimitation problem. And I do want to say, this is another footnote in answer to your earlier question. The tribunal made clear that in that case, there would have been a jurisdictional problem because there would have been a delimitation problem and they would not have had jurisdiction. The reason there was no jurisdictional problem is that they decided that there was no entitlement. On the final point, the tribunal recognized, let me just make this, that there were some states that had made baseline claims around offshore archipelagos, even though they were not archipelagic states. Archipelagic states have to be comprised exclusively of islands. The tribunal found those claims, in effect, to be not consistent with international law, and that's it. But the argument that there was some precedent in that direction is correct. I believe, and I hope Mr. Harris addresses this, that there's also precedent that some of those claims were not accepted.
Thank you, Bernie. I'm going to take groups of questions now. Do we have any from the floor at this point? Sir?
For Professor Oxman, before the decision came out, was there any argument of the Philippines that you found to be less strong or weaker than others, or is it your view that they all were equal?
And over here, do we have one? Mr. Mirasola.
Two questions. One for Dr. Hong. It seems like a common premise throughout some of your argumentation about customary international law and treaties is that customary interpretation should preempt a pure textual reading of the convention. And so I'd be curious to hear if you think if that is your position. And if it's not, then how are you interpreting customary international law in light of the convention? And then similarly for Dr. Oxman, you said that state practice has to be more than just a claim. So if it's more than just a claim, and what does it have to be? Does it have to be a claim that is confronted and is resolved? Is it a claim that is within the bounds of the travaux? Where are we drawing our line when we're kind of thinking about customary law?
Okay, thank you. We'll take one more. Was there one? Yeah. Go ahead.
This is for Dr. Hong.
Speak up.
This is for Dr. Hong. My sense is that the case has taken on a political life in
There's a
China.
microphone right next to you.
My sense is that the case has taken on a political life in China that's very different than the life it's taken on in other parts of the world, and in particular the U.S. And the positions I've heard about the case from well-educated Chinese colleagues have really had very little to do with the kinds of issues we're discussing in the room today. I was wondering if you can comment on your sense of public perception on the case in China and whether or not you think that discourse is healthy.
All right. Hong Nong, would you like to go first, or Bernie?
Please.
Thank you. And the question, I think, I don't have a very strong preference whether the treaty law or customary international law prevails. I think both should have a role in managing disputes, and we should find a balance point. Because the reason that I emphasize on the value of customary international law simply because many of the issues in the South China Sea was not really relevant to the interpretation and application of law of sea convention, particularly, for instance, historical rights, which existed. Well, when China claims historical rights existed quite long before the Laws Convention was ratified or passed in 1982. So, and also in the preamble of the Laws Convention, it does mention for those issues which not be able to be addressed by Laws Convention, to have to refer to customary international law. And also in the South China Sea, as I mentioned, it's mostly about these sovereignty issues in which we cannot actually refer to a Laws Convention itself. So, it's always very important, necessary to find a balance point. And we should not only rely on Laws Convention, although it's very important, providing many of the important regimes, such as in Canal Shelf in the South China Sea. So it's very important to find a balance. And the second question, sorry, I have to, using the microphone, about the public perception. And if we talk about the perception among the legal scholar in China, as I said, there's no single voice. And probably, particularly Professor Lynn, might be one of the very strong advocates for appearance in or utilizing third-party forum. I could be wrong, but you can explain later. And then there's a different views debate. But I want to share with you, we see quite a lot of difference before July the 12th, because after war of jurisdiction came out October 26th, actually we still see ongoing debates among scholars. And we see yes or no, but after July 12th, this final ruling came as a very surprising result for China, because I believe, when I read through the jurisdictional rule, I do believe that I was convinced by some decision by the tribunal, especially on 121.3 about the jurisdiction issues. But when this July 12th ruling came out, we see overwhelming one-side voice in China that maybe for those people who stand against China's position of non-appearance and non-participation, they tend to think that the government make a good decision from the very beginning that China should not participate, because many of the arguments say they see the ruling on the merits very unfair, and the tribunal has gone too much beyond jurisdiction. So I hate to say that it kind of destroys confidence among many international lawyer or international law scholars in China. They come to question about what's the value of the third-party forum in addressing or managing the potential conflict in the South China Sea. I hate to say that, but there's already different side of one coin. You see, on the one hand, they are kind of underestimated the role of the value of UNCLOS in managing the issues in the South China Sea. But on the other hand, we see an ongoing or increasing interest among the young scholars, thinking, in a different direction. So I would say the public perception is that some of them are very pro the Chinese government's position. Some of them, they are actually thinking maybe China should give itself a better case, an opportunity to present legal evidence before the international community.
Sure, James, yeah. Yeah, your microphone, please.
Dr. Hong said, I
Yeah,
hope
yeah.
I'm not going to lose my right to speak as a discussant. Well, on the very day of July 12th, we got notification from the university. I'm, working Tsinghua University. You control your students, now to sort of take this sort of arbitration award as a sort of very good excuse for public demonstration on the street. So I locked myself in my office, so you can see the national sentiment. That very much deals with the education of international law that we provide, we offer to our students. So what is the role of international law can play? In China, the prevailing, not including my opinion, the prevailing opinions, when international law can sort of serve the national interest, you apply it. When international law does not serve your national interest, do away with it. So this is a very adaptive, attitude towards rule of international. It's instrumentality, nothing but instrumentality. So I think that hurts very much today, and that also can explain the state of affairs. Just very quick stepping. Yeah.
All right, thank you. So I got to let Bernie respond to the question, sorry.
Well, I'm sure with respect to the first question, you were not expecting a full response, but I will say this. there are a variety of styles and approaches to argument you can make in a case. And I think most objective people in looking at the arguments made by the Philippines, and they are all on the website. You have the memorials and you have the PVs of the oral arguments, were quite conservative. It was not a let's throw everything but the kitchen sink at it. And I will just leave it at that. As to the second question, I mean, we could have a long discussion on how do you make customary international. Let me distinguish what the case would be in the case that would be cited the other way, which is the continental shelf, and you know, people announced that it was instant international law. Well, it's not that simple. The United States consulted a number of other states before it issued the Truman Proclamation on the continental shelf. It is true that two of the states that might have had an interest in protesting were under military occupation by the United States, but that's a different question at the time. And it is true that the United States claims were emulated immediately on a very, very wide basis. The problem in the law of the sea that we face that leads to the convention is that they were emulated beyond our wildest expectations. And there we stand. There were no protests. If you look at the records of the International Law Commission shortly thereafter, there is virtually no protest. Only the French member of the commission, Professor Sell, had questioned the doctrine of the continental shelf. So that this was a very different situation, and it's not as if there was no publicity. But in general, the mere fact that there are claims in and of themselves doesn't answer the question. And let me just say that leaving aside the burdens on Mr. Harris and his colleagues of trying to follow everything and make sure they write protest notes on everything, which is not an easy job, I've been there. The developing countries cannot conceivably rationally devote resources to that kind of an exercise. I mean, there are limited resources in the governments of developing countries, and I would not be the one to recommend that they have to hire 30 more lawyers in order to follow state practice on every issue and write protest notes. So if something pops up in the UN General Assembly, they're there, they can hear it, they may say something. But other than that, to take the position that things simply happening with no dispute and floating along make international law because no one said anything about it is one that makes me uncomfortable. Can you reach the point where there's acquiescence? Yes, and I will end with this example. Australia makes a submission to the Commission on the limits of the continental shelf that itself it describes, I think foolishly, as embracing 1 million square kilometers of continental shelf beyond the 200-mile limit of Heard and McDonald Islands. They were obviously, it's consistent with my position that when governments say things publicly, it's intended for home consumption. The 1 million square kilometers. A number of states, because it implicated Antarctica, actually submitted comments on the Australian submission because the other parts of the Australian submission implicated Antarctica. And not one state, challenged the Australian submissions in respect of Heard and McDonald, leaving aside strictly technical issues. There, I think you have something of a different record, because you have a record that other states paid attention, that they talked about the Australian submission, that they objected to portions of the Australian submission, and yet this started passing by. And there, I think you start having a bit more. Also, I want to say something, as long as we're on it, we'll say more about it in the next session. I don't think that you can take a decision that dealt with a situation in which the claims were contested at the outset, and in which indeed the claim to Ituaba standing by itself is not even made until close to the end of the proceedings by Taiwan. And only then is China probably politically forced to say something about Ituaba itself standing by itself, as comparable to situations in which claims are out there have been noticed, and nothing is said. I still have trouble saying that's instant law, but it's a different situation from the situation that was present in this case. And you have to be careful about recognizing that.
All right, well, we're going to have one more comment. That's Julian Ku. And then unless Dear Leader decides to expand the time, we're going to cut it off and get our coffee.
Okay. Thank you so much for letting me take the last. Building off the point about what I'm interested in is the impact of the award on China. I think it's very interesting. And I think what I'm worried about is that there was not enough debate within China understanding. I point to a CCTV report from May 2016. 300 Chinese legal experts gathered to discuss the case. Their analysis was unanimous. The China should abstain from participating in the case because the arbitration panel has no jurisdiction. 300 legal experts from the Chinese Society of International Law, every single one of them agreed. Okay, so if you were there, you would have been one, but it was a CCTV report, but they actually had cameras at the meeting, and they actually had the video of the vote. And every law professor put their hand in the air. 300 legal experts of the Chinese Society of International Law. These are experts in international law. And I can't remember the last time the American Society of International Law had a unanimous agreement on whether to have water or tea. I mean, there's nothing that they've ever agreed upon. And so the reason why I worry about that is because it suggests that China will not, and I think what you're suggesting, Dr. Hong, is that the image of international arbitration, abetted by, I think, statements from the government, which disparage the arbitral tribunal's independence, I think will lower the image and the significance and the reputation of international law and international arbitration within China, both among the legal experts who actually study it, but then, of course, obviously among the general public as well. And I think that is something that's worth thinking about as we go forward.
Well, that's great. Thank you very much. And everyone, please join me in thanking a terrific panel and discussion.